there must be a fiduciary duty. And Martoma 2 decision interpreted Dirks as allowing the government to prove a personal benefit through a gift, a relationship that suggests a quid pro quo, or an intention to benefit. And further, the government does not need to show a meaningfully close personal relationship when proving a personal benefit through an intention to benefit or a relationship suggesting a quid pro quo.
Legislation changes month to month, year to year. But over the last century, the changes have been astounding. Join Karen Woody and her students from Washington and Lee University to dig into 100 years of insider trading law.
Welcome back to the next episode of Classroom Insiders. I am your host, Professor Karen Woody, and I am joined today for the next installment of a discussion about insider trading by one of my students. So please introduce yourself, tell us who you are, and a little bit about yourself.
Hey, Professor Woody, it's nice to be here. My name is Lydia, and I'm a 2L at Washington and Lee Law, and I'm also a staff writer on Law Review. This upcoming summer, I'll be at Weil in their New York office, and I'm fascinated by both litigation and transactional work. So I look forward to the summer rotations to see what I'm more interested in. And in general, I find corporate and tech law the most interesting, and I hope to work and specialize in one of those fields, or in the intersection of the two.
Awesome. So maybe you will be able to carry forward everything you've learned about insider trading into the next phase of your career. Possibly.
I hope so.
So, Lydia, let's talk about insider trading then. Let's get into first a little bit of the background in case if anyone hasn't heard the previous episodes, just give us maybe a little bit of background of the evolution. It's sort of a 30,000 foot level of where we have come from, and that what gets us up to what you will talk about today, which is a more modern case of insider trading. 30,000 foot level, what happens in sort of this arc of insider trading regulation? Let's start with maybe before Justice Powell takes the bench. So sort of what was the general rule around insider trading before we see some of the shifts we'll start to talk about today?
Right. So insider trading was really regulated by states up until, I would say, 1960s, when President Kennedy appoints Chairman William Cary of Columbia Law, and Chairman Cary wanted the SEC to have broad regulatory powers and have the ability to heavily regulate insider trading. And we get this administrative ruling in Cary, where Chairman Cary provided a new federal basis for broad insider trading enforcement powers. While it was merely administrative, it was adopted by the Second Circuit in the Texas Gulf Sulfur, or TGS case, which gave us the famous disclose-or-abstain rule, which created a duty to disclose or have the option to abstain from trading for anyone with information intended to be available only for corporate purposes. And this decision in the case would stand for essentially the next decade as the preeminent insider trading rule until we get Chiarella and Justice Powell.
Okay, so general disclose-or-abstain applies to anyone with material non-public information. Essentially, it's a prohibition on trading if you are in possession of that. And then that shifts when we see Justice Powell ascend to the Supreme Court, and we see, as you said, this Chiarella case. Tell us a little bit about Powell jurisprudence and what you know about it, and what are some important decisions. What does he shift in terms of insider trading regulation?
Right. So Justice Lewis Powell, most importantly, a W&L alum, was appointed by President Nixon in 1972 and served on the bench until 1987. And he was known as the business law or corporate law justice. So it's only fitting that he wrote the majority opinions in some of the most, if not the most important insider trading cases like Chiarella and Dirks. And he was just wary of the SEC broad regulatory reach and wanted to put a check on the agency.
What was the reasoning behind why he wants to check the SEC? Does he have some vendetta against them, or is that's just his background that he didn't like agency overreach?
I believe so. I think he was just uncomfortable with the fact that this agency had such broad regulatory powers, and with his knowledge and his background, he wanted to put a check on that.
Okay, that makes sense. And so, well, we'll get to this later about maybe what Powell would have thought about just completely doing away with insider trading regulation entirely. That is something we can discuss once we maybe get through a little bit of what the decisions that he did write that change the structure of insider trading. And so what were those? What's your understanding of the important Powell decisions?
So he starts with the Chiarella case, and that's where we get the fiduciary duty element. And that's, I think, the first time when we see Justice Powell really chip away at the broad TGS abstain or disclose rule. And then we move on to Dirks. And in Dirks, we have a tipper-tippee insider trading case. Raymond Dirks was a securities analyst who uncovered a massive fraud scheme, but in doing so, disclosed the results of his investigation with some clients, and they in turn traded on that information and avoided substantial losses. So instead of rewarding Dirks for uncovering a fraudulent scheme, the SEC charged Dirks with violating the federal insider trading prohibition. And we get a majority opinion written by Justice Powell, where the court reversed and established a new standard for insider trading. So adding on to the fiduciary relationship established after the Chiarella case, here the court added a personal benefit element, and the opinion established a personal benefit test where courts must determine whether insider tipper personally benefit directly or indirectly from disclosure.
What are the three things that Powell, or examples maybe that Powell said of what would indicate a personal benefit?
So there are three examples of a personal benefit test: pecuniary gain or money, reputation gain, or a presumption of benefit due to close friend or family member relationship.
All right, so let's unpack this a little bit into lay terms. So essentially we have, if you are in possession of material, non-public, insider information, before Justice Powell takes the bench, you had to disclose that, which you likely wouldn't be able to. You just had to abstain from trading. So then Powell introduces these new elements to make an insider trading claim. And that the first, as you said, was a fiduciary relationship. That's Chiarella, where he says, absent a duty to disclose, silence is not fraud, or certainly doesn't rise to the level of insider trading. Again, seen in this lens of this is all based in fraud, a fraud regime. And then in Dirks, he adds to that, if there is a tipper-tippee relationship, the only way that there's a problematic, that there's actually an insider trading issue is if the tipper has received a personal benefit for the information or for giving out that information. And I guess, does that apply to a prosecution or enforced action against both tipper and tippee, meaning the tippee had to know about the benefit that the tipper got? How does that work? Does that apply to both of those actors?
I believe, yes. The tippee had to have known that the tipper personally benefited.
Correct. Okay. Because that's actually what we got into a little bit in the Newman case, which we talked about in the last episode with Colin, this idea that if you can create enough distance between the original insider, if we call that person the original tipper, and the ultimate trader, if you can't establish that that person knows about any benefit that the insider got, that might not meet the personal benefit test. And so you're not guilty of insider trading if that's the case. So we saw last week the Dirks test in reality or an application 20 years after Dirks was decided. So we saw how this gets trickier and trickier to when you see new and different fact patterns of what it means to meet this personal benefit test. And again, how much it gets away almost from common sense in certain times. For instance, in the Newman case, actually, you tell me what happens in the Newman case. Do you recall that case?
Yeah, there are essentially two chains of tipper-tippees in Newman, and both stemming from insiders at, I think it was NVIDIA and Dell. And there were multiple layers, 5 layers removed in the case of Dell, and then 4 layers removed in the case of NVIDIA. And what happened was the initial tipper would tip an analyst who would then tip another analyst, and so on, until the final tippee traded on that information. And in this case, I think that was Newman, and she had some, if I'm pronouncing that correctly, the personal benefit standard was in question in Newman, and there were 2 long chains of tippers and tippees who traded on material non-public information, essentially.
Okay. And so what did the court end up, or I guess it's the Second Circuit for Newman, what did they end up saying about those long chains of tippers?
So the Second Circuit applied the Dirks test and found that the insiders did not receive a personal benefit for the tip. And the court held that to establish a 10b5 tipper-tippee liability, there must be a fiduciary duty. And then the corporate insider breached his fiduciary duty by disclosing confidential information to a tippee in exchange for a personal benefit. And the tippee knew of the tipper's breach, and the tippee still used that information to trade in the security or tip another individual for personal benefit. So essentially, the Newman opinion further curtailed the insider trading laws, specifically around the personal benefit element, and the holding amended the third element of the Dirks personal benefit test and added that the relationship must be meaningfully close and there had to be a pecuniary gain.
Okay, so interesting. So if Newman adds to the test in the sense that the court says, well, this relationship of trading relative or friend needs to be meaningfully close in order to assume that there's been a benefit here. And the court also adds to that a pecuniary gain needs to be present in order to show how close that relationship is. Isn't that sort of conflating some of the elements of the personal benefit test that we saw in Dirks?
Yeah, it's essentially folding the first and the second elements of Dirks together.
Okay, and so that strikes me as a pretty big shift. So Powell says, all right, here are examples of personal benefit that you have to show if you want to find someone guilty of insider trading, either as tipper or as tippee. And so now, again, Second Circuit says, well, that has to be a meaningfully close relationship and one in which there is some exchange of money or something of value. That's a pretty significant narrowing of even the Dirks test, which, as we said, was already a significant narrowing from the disclose-or-abstain broad prohibition on trading. And so what happens after Newman is decided? Does the Supreme Court take up Newman?
No, the Supreme Court denies cert in Newman, but we get Salmon.
All right. So, yeah, what happened in Salmon, and how does Salmon have any bearing on the Newman decision?
So the court had a chance to revisit this pecuniary gain element attached to the meaningful and close relationship test in the case of Salmon. There, Bassam Salmon traded on material non-public information about an upcoming merger and acquisition deal that he learned through his sister's fiancé, who learned that information through his brother, who was an insider. And writing for the majority in the unanimous opinion, Justice Alito focused on the personal benefit test from Dirks. And the court held that the personal benefit test had been met because Salmon was a trading relative or friend, even if there was a chain, and he was not directly told his information by the insider. And moreover, the decision amended the Newman's holding by removing the pecuniary gain element where there is a relationship presumption. So here it seems as if the insider trading laws were starting to basically revert back to the TGS-like standard.
Maybe, but they don't go that far. We're definitely back at Dirks. If Newman moves Dirks a little bit, I don't know if we call it right or left, whichever, it narrowed Dirks. This pushes us back to the language of Dirks, I think. That's my understanding of Salmon. So what do you think about this? Do you think that the Second Circuit got it right with Newman of making this trickier to bring an insider trading case? Do you agree with Salmon, which is essentially the Dirks test? What do you think about this up until we'll get into the cases that we'll talk about today? So up until the cases that we'll talk about next, what do you think about status of insider trading law from the court?
I think the narrowing of insider trading by the Newman case was unnecessary. So I like that Justice Alito brought it back to more of the Dirks standard. Even though I don't even agree with Dirks, I think we should be going back to the TGS broad standard of a disclose-or-abstain rule.
Okay. Well, we'll get to that next. But before we get to that, we get sort of your broad opinion on this. What is the case you are going to talk to us about today? Because we've dealt with a little bit of each of these cases that we've been discussing in previous episodes. But you are going to take us to the next step, which is the Martoma case or cases. So tell us a little bit about those cases. When were they decided in relation to Salmon and Newman? Set the stage for these cases.
Right. So United States v. Martoma is another case that almost brought back insider trading laws to the TGS days. And fun fact, the show Billions is based off of the Martoma case. So going back there, Matthew Martoma worked as a portfolio manager at SAC Capital, a hedge fund managed by Stephen Cohen. And at SAC, Martoma managed an investment portfolio that was focused on pharmaceuticals and healthcare companies, and he recommended investments to Cohen. Martoma acquired shares in two pharmaceutical companies, Elon and Wyeth. which were jointly developing an experimental drug to treat Alzheimer's disease. And additionally, Martoma recommended that his boss, Cohen, also acquire some shares in the two companies. And it turned out that Martoma was meeting with doctors and paying them for consultations in return for confidential information about the trial, the drug's effectiveness, and the patient's responses. And the most consequential piece of information was Martoma receiving the final results of the trial before it was disclosed to the public. And in between learning about the information and the public announcement at a conference, SAC reduced its position in the two pharmaceutical companies by entering into a short sale, which resulted in approximately, I think, 80 million in gains and close to $195 million in averted losses. Subsequently, Cohen was charged and convicted of insider trading. And what's riveting about this case is there were two decisions 10 months apart, and where in the First, the Second Circuit affirmed Cohen's conviction and held that with respect to the personal benefit test, any relationship will suffice. It does not have to be meaningfully close. So essentially overruling Newman. In other words, any relationship will meet the Dirks element of the presumption of benefit due to a close friend or family relationship. It did not have to be meaningful and close.
Okay, yeah, but if we go back to the facts here, Martoma is an analyst, is that right, for Stephen Cohen, SEC Capital.
SEC,
SEC Capital, and is chatting with some doctors or an expert doctor, it sounds like. So he gets information before that information is released and they trade on that. Well, I guess I should say, my first question is this something that happens regularly? Is the Martoma, does that setup occur all the time in investment or hedge funds? I have to imagine that this is something that's not atypical for a number of hedge funds to have an expert network or something where people give them some, maybe tell them which way the wind is blowing on certain investments. So in your reading of Martoma, why are we here that Martoma is getting dinged for this?
Yeah, so from my research, it's apparently common to have these consultations with doctors. But what's interesting in this case is that these doctors actually break their confidentiality agreements and disclose information that shouldn't be disclosed, get paid for it, and then give this information that was non-public material. And then Martoma is able to basically trade on it or, avert losses based off of that information.
Okay, so typically the expert network is just someone saying, just a doctor opining about something that's not the confidential business information for the company which he works. Okay, well, that makes more sense. But I get how it would be easy to maybe pretend like he's just giving that general expert advice and isn't divulging this now, essentially front run information before about the trials. Okay, so then Martoma trades in his personal account, or what happens? He trades himself and also tells his employer.
He tells Cohen, and then they collectively, they short sale. They just get rid of their stake in these two companies because they know that the Alzheimer's drug wasn't as successful because they learned that the patients didn't really, react the way that they were hoping for. And before that information is disclosed to the public, they're able to avert losses close to $200 million.
Okay. And so under the current post-Newman, post-Salmon, I believe, Salmon is maybe out and decided by the time Martoma is working its way up through the courts. If we're in the Newman, so we're in the Second Circuit again, and if Newman applied, could the SEC win this? I'm just thinking through this idea, but what the court says here in Martoma, they basically toss the Newman idea that there has to be pecuniary gain, essentially, the first time. Is that what you said? They said, no, we don't need a pecuniary gain here, nor do we need a meaningfully close personal relationship, right?
Exactly. Yeah, they were saying that any relationship will meet the Dirks element of the presumption of benefit due to a close friend or family relationship. But yeah, you're right. Looking at Newman and looking at the personal benefit test, you could probably prove that this relationship was meaningful and close. He worked for Stephen Cohen. He was advising him. They were pretty close. It wasn't just a random, relationship. This was a close employer-employee relationship. And it did really include a pecuniary gain because, as we see in Martoma 2, the conviction stands based off of the pecuniary gain to one of the doctors.
Right. So I guess if we still were in the land where Salmon hadn't been decided, the SEC might have still been able to win this even under the Newman constriction of what insider trading is. Basically, it's a harder road for the SEC or for the DOJ, I guess it is here. So, but even still, they probably could have made these facts clear. I remember the court diving into this, what is a meaningfully close personal relationship? And then, as you pointed out, I think going the entire other direction, which was any relationship likely meets this. And if you know the person, it's probably enough to say, you are now been given inside information. It's almost that they have codified this gift theory, which is, even if I don't know you that well, the fact that I have now handed you some material non-public information, that, like you said, moves us a lot closer to a disclose or abstain era, or that idea, because anyone who's now has this, and whoever I give it to, likely we will meet a personal benefit test. And I hear that's what you're saying that Martoma 1 said. That's what they were trying to get to, this sort of much broader understanding of what meets the requirements of insider trading. And so you said then what happens 10 months later? Is that right? How much longer? And then then what happens?
Yeah, so 10 months later, Martoma asks for an en banc review, but gets another amendment decision in Martoma 2, where we get the same judge, and the court backtracked its previous holding that any relationship would create a presumption of personal benefit, and instead affirmed the conviction on the grounds of a pecuniary benefit to one of the doctors. So the court affirmed the conviction on the grounds that Dr. Gilman, the tipper who disclosed confidential drug trial information to Martoma prior to its public announcement, received a pecuniary gain since he was compensated handsomely for his quote-unquote consultations.
Okay, so what was the triggering event then that why the second opinion was issued?
From what my understanding, there was a lot of backlash from a lot of, I think, attorneys and think tanks, and the court was compelled to give another opinion. But from my understanding, the Second Circuit was unlikely to, I think, state or issue an en banc review, because that has happened in very, very few times in the last decade. So that was unlikely to happen anyway.
Yeah, it is almost this wild circumstance where the court just takes a mulligan and rewrites their own opinion with almost a year later without doing an en banc review. It's a very fascinating procedural background to it, if there even is a reason for the procedure. They really just rewrite it. They start over. They come out, it sounds like the same way, but the reasoning is a little different, which is, this is still insider trading, but maybe we have swung for the fences maybe a little too much by trying to write into this that any relationship meets this test. And instead they said, well, okay, it's a little bit of a harmless error because he's still guilty of insider trading, but he's guilty because we can show that he was paid for information, which we know meets the personal benefit test no matter what, under any of these regimes, under Newman, under Solomon and Dirks. And then obviously, so either one of these, this is problematic that you're getting paid for this. Is that your understanding as well? That's how the court ended up where it did?
Yeah, and I would say that Martoma 2 interpreted Dirks as allowing the government to prove a personal benefit through a gift, a relationship that suggests a quid pro quo, or an intention to benefit. So I think that's where we leave off.
So where does that then leave the SEC? And where does this leave the state of insider trading regulation at this point? Now that we have, again, if we take the full arc, we had disclose or abstain, don't trade at all. Justice Powell narrows that significantly. Fiduciary relationship is required. And then under Dirks, there has to be a personal benefit you've received if you've tipped or handed this information to someone else. Then we see that there, even in these modern sort of last decade cases, where the courts are grappling with the extent of that personal benefit test. One of which is, do you have to have quid pro quo or some pecuniary gain? Newman said yes. Of course, Solomon undid that. Then we went to Martoma here, and they tried to swing it the other way, which was like, you know what? All you need is any relationship, and that would be enough. So they really did say, if someone gifts you insider information, you are guilty for trading on it if you trade on it. So much closer to disclose or abstain. And then they dial that back. They rein that back in and say, well, okay, fine. We'll just go back to the Dirks standard, and we end up in the same place. So where are we then? What does the SEC need to show in order to bring, or the DOJ, what do they need to show in order to bring a successful insider trading case?
So my understanding is there must be a fiduciary duty. And Martoma 2 decision interpreted Dirks as allowing the government to prove a personal benefit through a gift, a relationship that suggests a quid pro quo, or an intention to benefit. And further, the government does not need to show a meaningfully close personal relationship when proving a personal benefit through an intention to benefit or a relationship suggesting a quid pro quo. I think that's where that leaves us.
Yeah, and that certainly is where we are today. We haven't had a lot on Tibber TP since then. I mean, certainly there have been cases, but we haven't seen a major shift in the law in the same way we saw in these important cases. Let's get back to your thoughts about this. What do you think about this state of the law? What would you change if you could either legislate this or just waive, just have some ability to write it from scratch? What would you say about how we should be regulating insider trading, if at all?
I think the SEC and Chairman Cary got it right in the 1960s. I'm one of an opinion that the TGS abstain or disclose ruling was the most precise and accurate holding on insider trading. So if there is a non-public material information and you trade on it, you should be held liable under 10b-5. There's always an option not to trade on that information, right? And I also believe that equal access to information should be the primary force behind hopefully future insider trading laws. And I think the current state of insider trading laws it just deeply frustrates me and comes close to, I would even say, violation of some of the due process rights, because the laws seem to be a little unclear and vague, especially in cases that are not cut and dry insider trading cases. And the decision in Martoma 1 might have been more accurate holding of what insider trading laws should be, but we keep seeing a lot of legislating from the bench that comes as a result of an anemic legislature, essentially. And I hope to see congressional leadership on the matter that will hopefully shed some clarity to a much needed area of corporate law.
Okay, so you think that's the best avenue or pathway to solve this, is to have a legislative fix for insider trading?
I agree. Yeah. I think if we had Congress come up with some legislation, it would give the courts the ability to maybe interpret that law, but have a bill to look at while they're doing it, not just come up with new laws on the spot.
Okay. I'm trying to think of how to be devil's advocate and argue the Powell side of why disclose-or-abstain is overly broad, but you did such a convincing, you convinced me so much that I'm having a hard time formulating it. In part because of things that are a little more esoteric, like Reg FD solved some of the problems I think that Powell was addressing when he was trying to allow analysts and other people in the market to ascertain some of this information for the benefit of the market and for accurate price discovery. I think there have been places in the statutes that have fixed that a little bit. I think Reg FD moves the ball somewhat. And so I'm trying to think of what else to ask you, that because you definitely staked your claim on disclose-or-abstain. I appreciate that. That bold move. That's good stuff. What do you see as maybe a weakness, if any, in a disclose-or-abstain stance?
I think it's still pretty vague, though. That's the issue. It's the due process issues that we keep seeing. Yeah, just from the point of vagueness of the law, like what do we mean? What is it all encompassing? And I think really, if Congress were to come out with some sort of bill or ruling on this, they would need to maybe provide examples or situations where, okay, so if you're flying on a plane and you see someone's laptop on, and they see some sort of confidential information, and then you decide to trade on it. Okay, is that insider trading? Like, what happens there? In my opinion, yes, it is. Definitely 100%. Enforcement wise, I don't know. I think that's an administrative nightmare. But if somehow someone learned that you did that, I guess you should be on the hook. Again, there's always an option to abstain from trading. No one is making you do it. Yeah.
So this is sort of similar to like a shadow trading idea, which is I learned something and I can do the math quick enough to realize that even if I don't trade in that company where I've learned something about that particular company, I can figure out what other companies that news will affect and trade in them. And you're right, could be potentially problematic, but also maybe a nightmare to try to regulate or to track. And it does, I think, beg the question that what then is the role of analysts or the role of people does that chill, I don't know if you call it innovation, but chill some sense of aggression to find little pockets of what I think they would call the edge if you're watching Billions. does that shift how people in the entire industries that are built up around exactly that idea, which is I'm going to figure out how to suss out the edge. What do you think about that?
It could have a chilling effect, but at the same time, I think they should err on the side of, okay, if this seems fraudy, maybe we shouldn't be doing this. Again, you can always abstain. And just because you don't trade that second and maybe you lose a little bit of money, I think it's safer to err on that side than to trade and potentially be held liable for insider trading. An alternative would be to have different laws for maybe even different industries, or have actually say insider trading laws, because right now, 10b-5 doesn't even have the wording of insider trading in it, which is the funniest thing, because we apply it to, we associate obviously insider trading with 10b-5, but the language, the words are not even in the rule. And that's probably another fix that Congress should articulate.
Yeah. Well, this has been fascinating. I've learned so much about both Martoma and then this broader idea of how we should regulate insider trading. And so I appreciate your thoughts and opinions about that. Do you have any parting thoughts, any wisdom you want to share with our listeners before we go?
Sure. Yeah. I really just hope that Congress steps up and something gets done. And again, you can just abstain. You don't need to trade on that information. If it feels a little fraudy, don't do it. It's okay.
I love this. I love that fraudy as an adjective is a good one. I'm going to have to work that into more of these podcasts. Well, Lydia, thank you so much. This has been a delight. I appreciate your time and your expertise on this. And so I will hope that everyone continues to tune into these episodes. We have more to come and different theories of insider trading as well. So thank you, Lydia, and thank you all for listening. We'll be back here in a week.
Thank you.